Begin. Thanks everyone for your patience. I'm Andrea Marcin. I am an Equal Justice Works Fellow here at MVLS. Hi to the other fellows who are on the call right now. Caitlin will introduce herself in a moment. She may be well known to many of you. Today we're going to talk about practical strategies for working with older adults. I've noticed that I've been to a lot of webinars, meetings over the past 2 years of my fellowship, and they tend to really talk about very science-based topics like assessing capacity or more really theoretical frameworks. So we just wanted to give participants practical strategies for working with those clients.
Thanks. My name is Caitlin Tepe, and I work at MVLS as well, and I am in the guardianship unit. Prior to coming to MVLS, I worked at Maryland Legal Aid. That's where I started my career. And I did administrative law and then moved on to some housing and consumer, and have always worked with older adults in all of the capacities that I've done so far. So we will just jump right in. So I just kind of want to go through what we're going to be discussing today, the goals of the presentation. We're going to first just talk about ethical issues for attorneys, and we love to make sure that we're always covering ourselves. So we're going to touch very briefly about capacity and decision-making supports, unconscious bias and third parties. And then we're going to kind of get into the best practices when communicating with older adults. We are going to address both in-person meetings, written words, letters, and then telephone and video conferencing, which is very prevalent right now during COVID. Okay. So the first kind of thing when we speak to any of our clients, but particularly older adults, is capacity. Attorneys who work with older adults will inevitably face the challenge of determining whether a client or a potential client has decision-making capacity. So when we meet our clients and meet anyone, capacity is presumed. I mean, regardless of what other doctors' opinions have, or whether or not that's the exact legal issue that brought you to this client, we're going to presume that they have capacity. And then as we discuss the legal issues with them, if certain things come up that make us think that there might be some diminished capacity, we as advocates have to look into that. And we need to be conscious that our client could have capacity for one legal issue, but maybe not another, because capacity is this fluid concept, and it depends on the circumstances of the individual and then the decisions being made. And the definition of capacity is going to change depending on what legal issue you're talking about. So for guardianship, we have a very specific definition of capacity, which says that the court determines through clear and convincing evidence that a person lacks sufficient understanding or capacity to make or communicate reasonable, responsible decisions concerning this person. So we're going to be referencing this a lot, but the ABA has released an updated handbook called Assessment for Older Adults with Diminished Capacity. We're going to link it in the chat, but they have this really great capacity worksheet for lawyers. And so if you meet a client and you suspect there might be some capacity issues, you might want to bring this worksheet with you. And again, I'll throw it in the chat. Nickler had created a really great worksheet that included it, where you're just going to kind of take note of some signs that maybe there's some diminished capacity. So that's something that you can do as you are meeting with your client. So under the ABA handbook, they said that there's basically, 3 immediate capacity determinations you have to make as an advocate when you're meeting with anyone, but then again, specifically when you're meeting with older adults. So the first is going to be, does the client have the capacity to contract my services? Meaning, can I enter into a retainer agreement with this client? If you can say yes to that, you can go to number 2, which is, does the client have the capacity to understand and complete the legal transaction, right? The will, the contract, whatever the legal issue is. And then the third is kind of what we're going to dive into today, which is, are there supports and services that might address my concerns about capacity that would allow my client to either retain me or complete that legal transaction? And we believe that advocates can enhance capacity of their clients through, effective communication and decision supports. So the different types of decision supports, again, a lot of this is from the ABA handbook, is, let's say you meet with your client and you walk away and you say, I just don't feel like that information stuck. I don't think that she really understood the options that I was presenting to her, or what the legal issue was, or the ramifications of that choice that she just made. So I might go back to my office and say, what supports could be possible for us to have another conversation that might be able to enhance her understanding and her ability to make decisions. So, there's technology, there's apps, there's interactive software, there's environmental aids, right? The ability to see or hear. Was there a lot of background noise? Was I sitting too far away from her? All of the types of environmental factors that might affect someone's ability to hear you, understand you. Emotional supports, ensuring that when we are helping our clients make decisions, that it's in the least stressful place possible, or without time constraints. So I do not want to be sitting outside a courtroom, telling my client, quick, we're in the middle of negotiations. Do you want to do A or do you want to do B? I mean, that conversation would hopefully have taken place prior to walking into that courtroom, right? That we might walk in, we might see the landlord, they might offer us A and B, or we might see the AG and they might offer 6 hours of care or 8 hours of care. Let's talk through this. Let's decide, what we're going to be willing to settle for or not. So we want to be able to try to have those conversations beforehand, or even having the conversations, the initial meeting, in a less stressful place. So is the home going to be the best place to have that conversation, or is there a lot of things going on in that home that we have concerns about? And so we're going to have that initial meeting at the library or at my office. And then lastly, people supports. We're going to talk about third parties and how older adults often have other people involved in their life. Maybe we had that initial meeting without the daughter or son there, but we realized that that our client is saying, look, I really want them present. They informally have been helping me make decisions for years. And we say, okay, let's pull them in and let's see if that person can enhance my client's understanding of the options and choices that I presented to them. On the flip side, while we're thinking about what supports could enhance our client's capacity, we also want to question what factors may have impeded the client's decision-making. So then, I will often leave meeting with my client and say, I think there was some diminished capacity there. What factors were present that may have impacted that I could change to have another discussion or another meeting? So things like, were they in the hospital? Were they recently experienced trauma? Are they having ICU delirium? I don't know if you've ever been in the ICU, the noise never stops, the sounds, the lights, it's extremely hard to pay attention. And while maybe you need a quick answer, those types of things, those factors could have impacted the client's ability to understand what you were saying and give an answer. And maybe when they get out of the ICU, or there's some time between the trauma that they just experienced, they're able to kind of engage in that conversation more. So these are just considerations that us as advocates need to be mindful of when we are thinking there might be some diminished capacity. There's a very strong role for us to play in both thinking of supports that can enhance it, and then thinking of the factors that might have impeded the client's ability in the front end. Okay.
So you may have seen the model rule before. 1.14 addresses clients with diminished capacity. And really the central tenet of this model rule is that we need to conduct our relationship with the client as close to a normal client relationship as possible if they have some capacity concerns. If they do have some concerns, obviously there's a menu of choices you can take. For me, that's often discussing with my supervisor. Perhaps you may need to discuss some of the issues that you've noticed with representation with bar counsel, but it's also just so important to respect confidentiality rules. Those same confidentiality rules that govern our communications with any other client also apply here. And that's important when we're working with third parties, especially family members who are nosy and want to know what's happening with mom, as well as people that we may be availing ourselves of to assist if we have an ethical issue with our client and we're not sure how to proceed, or if we need to take some protective measures. So I just restated in more plain English the context and the gist of the rule. So we wanted to touch on unconscious bias here, and there's many different parts of unconscious bias that we need to think about when we're dealing with older adults. The first is just the stereotypes we have about older adults, or as the nomenclature used to be, the elderly, even just using that as a noun. I think it's important to honor how the client wants to be known as. Older adult, I think, is kind of a newer phrase in the field. So a lot of my clients refer to themselves as senior citizens and, defer to that. Always using Mr. and Mrs. when you're speaking to your clients, when you might use first names with other clients. And we keep talking about assuming capacity. And that's so important when we first meet that older adult client. We have all these conceptions of older adults being frail, or they can't hear well, or they're lonely and vulnerable. But on a micro level, talking to that client, that may not be true at all. So it's really part of a client-centered approach to just meet your client where they are. Try to drop those assumptions you have about older adults when you are meeting them and speaking with them. We have a tendency to infantilize older adults. We say, oh, look at the cute old couple there, or we sometimes use a higher pitched voice. We speak very slowly, and there's a difference between speaking clearly, which it may be necessary when working with an older adult, versus yelling because you assume they can't hear, which is aggressive, or just speaking theatrically slowly, or the way you may do with a child. So again, just be mindful of the way that you are speaking with them. And being client-centered is all about empowering your older adult clients, not assuming that you know what's best for them. And if they make a choice that's different than what you would do, that's part of agency. That may not be part of capacity. You may be someone who's not very religious, and it wouldn't even occur to you to give 10% of your income to the church. But if that's really important to your client and you've established that through an open and reflective conversation, then who are you to advise differently, unless there was some sort of abuse factor present. So it's really just all about open and active listening, not cutting the person off. I think early in my practice, I had the tendency to want to answer people's sentences. And again, an older adult may take a little bit longer to answer your question, but don't just jump to what you think they're saying, because that's putting words in their mouth. And again, that's denying them of their agency and depriving you of what they're really thinking about. So going to third parties, this is very, very important when we're working with older adults. In addition to maybe still having a spouse that's living, they often will have informal supports, a person living with them, a trusted neighbor, a niece or nephew that performs daily tasks for them that or does a few things, helps them with phone calls, or maybe takes them to the doctor. Often at Maryland Volunteer Lawyer Service, that third party will call first on behalf of their mom. Oh, mom needs a power of attorney, usually because mom and daughter, maybe daughter's trying to help her with her banking or some other thing, and the bank said, you need this, and daughter says, okay, I'll just take care of it. But the daughter's not the client. The older adult is the client. They're the one that's going to be executing this really, really powerful document in the case of a power of attorney. So we're always ensuring that we're speaking with that client alone first. I think that that's also a really good sign if there's elder abuse present, if that younger person in their life gets it and says, oh yeah, I understand, I'll leave the room, or is reluctant and you to leave the room, then I think, your spidey senses will go off in that respect. It's always also important if that older adult consents to having that person in their life or involved, obtaining third-party authorization, and just especially in longer matters, ensuring that these two people know their roles. The older adult is the client, and the son or the nephew or the neighbor, whoever is, sometimes a part of those phone calls with the client, isn't overstepping. I have a hypo here, and this kind of happens a lot. I have clients whose children have cell phones and maybe can hear a little bit better. And they're the ones, it's just so easy to call that younger person and have them try to pass along a message. But maybe you could use that person to set up the meeting, to set up the Zoom, to hand the phone to your older adult client, but don't just default to talking to that daughter or son. You may be totally confident that they have your older adults client's best interests at heart and are not in an abusive situation, but in terms of remaining client-centered, just remember who's the client. Let's see.
Now great. So we're going to move into best practices, and I'm going to cover the in-person communication. And, I know that on the live call here, we have a lot of advocates from Maryland Legal Aid, and I'm sure that a lot of these things you guys already implement in your practice, but sometimes it's helpful for me to kind of sit down and remember these kind of tips as you kind of continue to do this. So the first is going to be the scheduling before you even meet the client. You want to think about the time of the day that you're scheduling the appointment. Typically people are kind of more alert, more awake in the mornings. You might ask your client, when do you normally schedule your doctor's appointments, or when do you normally run your errands? And that'll kind of be indicative of when they feel the most alert and the most energetic. And then you'll want to schedule your appointments with them during that time. You want to avoid, the afternoon or the evening as people start to sundown and get tired, and it's a little bit harder to focus. Then you want to think about where you're going to meet with them. Ideally, you'll meet with them in their home if that's safe and convenient. They're often more relaxed in their home. They haven't had to endure the stress of travel or figuring out how to get to your office or how to get to the library. And it gives the attorneys a huge amount of information in terms of real world functioning. We can actually see the window or the broken door that they want to talk about in housing, or I can see, any modifications that they might need in the home, or I can see in person how they look, whether or not they need assistance with ADLs. And so it's just really, really helpful for us to be able to get inside their home to be able to take in all of that additional information. We also want to, as we've talked about, is meet with the client alone first, if possible, ask whoever is living in the home to go into a different room or take a walk to try to make sure that we filter out any undue influence or possible abusive situations. The other thing that I like to do when I'm working with older adults is just have a preset time to take a break. I try not to ask the client, do you want to take a break? Because they're almost always going to say no. They don't want to feel like they're slowing the process down or they're, imposing in some way. So I'll say, we're going to talk for 15 minutes. We're going to talk about this one issue. And then I need to, make a phone call. I need to check an email and give the client an opportunity to kind of digest the information that you've given them, think about any questions that they might have, take a breather, and then kind of come back to the table to talk about the next issue. And then I'm also going to make multiple short appointments, right? I'm not going to make one appointment and say, see you at the hearing after the end of the appointment, right? So I normally, in my practice is guardianship, which is, very serious and the most restrictive thing that can happen to someone under the law. And so sometimes that initial meeting is just kind of shock. It's like, I'm the first person telling them about the petition, and it's hard to kind of move on from that. So sometimes we have a short first meeting to kind of just talk about the petition, talk about what it means. And then I'm going to stop and I'm going to let them kind of process that information. I'm going to let them contact family or friends or whoever else they want to kind of process this information. And then we're going to meet again. And now we're going to talk about family and friends that are involved in their life. And then, the last meeting is going to be the pre-trial meeting. And that's always going to be, maybe the day of the hearing, maybe the day before, so that they're fresh and so that the information stays, hopefully at the forefront of their minds when we walk into the hearing. And so it's important to kind of break up these meetings, even if it's time consuming, and even if it means we're going back to the facility or going back to the house multiple times. I think that it's really important to break up the information, have it be less overwhelming. And then I'm checking and reassessing for comprehension and capacity at every step. So at the next meeting, I'm going to talk about the things that we talked about at the first meeting and kind of rechecking what information was retained and what additional questions that they might have. And then, a translator, maybe the client said, I don't need a translator. I'm totally fine. You get into the meeting and it seems like there's a miscommunication not going on. So maybe you say, next time, would you mind, we'll pay for it. My firm will pay for it. We're going to bring an interpreter and just see if it helps the two of us kind of convey this information. Of course, there's always a preference that the translator is in person or the interpreter is in person as opposed to over the phone. But, I know with our current conditions, that might be difficult, but it's just something to kind of look into. Okay, and so then, your introduction, when you meet your client, you want to build a friendly rapport. And I'm sure most practicing attorneys try to do this, but I know sometimes, like if I have a lot of things going on that day, I kind of just want to come in and say, okay, you got a breach of lease. Let's talk about this. And that's really not best practice, right? You want to build trust with this client. And especially our older adults have been very isolated in the last few years. They haven't seen a lot of people. They maybe haven't built those trusted partnerships. And so if you're in their home, comment about a picture that you see, about something that you see on their wall, talk about their family. If they offer you something, take it and start kind of building that relationship. Another thing I try to do is figure out who else they've been working with to see if we know somebody in common. Maybe it's even another attorney in my office. Oh, I saw in my notes that you worked with, a coworker of mine, or, this social worker you work with, or this doctor, and I know that person too. And that kind of builds trust that we're kind of a part of the same community. We know the same people. And hopefully that allows my client to open up and give me some, the information that we need to take their case. And then something that I'm always reminding myself, and I'm probably talking too fast right now, is to just slow down, just slow everything down, slow your speech down, slow down moving from one topic to the next. When you're rushing or when you're speaking quickly, it makes people feel unheard. It makes people feel like they don't want to, bring up issues because you clearly have somewhere to go. I recently read that doctors on average will interrupt patients within 18 seconds of meeting them, that most doctors will interrupt you within 18 seconds. And that once interrupted, the patients are much less likely to reveal his or her concerns. So like Andrea mentioned, you really don't want to interrupt them. You want to be able to, have scheduled a long enough time to not rush anyone, allow the time for word finding. Maybe you give more moments of silence after questions than you are used to, and then only addressing, that one issue at a time before moving on. Okay, so then we're at the client interview. When you meet a client for the first time, you want those open-ended questions. And then as you get more involved, you're going to narrow down your questions. But, I would never kind of walk into a hospital and say, hi, my name's Caitlin. I'm your attorney. Do you want to consent to this guardianship? That makes no sense. That doesn't mean anything to my client. So I'm going to talk about things that are involved in guardianships, right? Do you want someone deciding where you're going to live when you leave the hospital? Do you want someone deciding what medical treatment you're going to receive? And so I'm going to ask very simple questions that require brief responses so that, again, I'm continuing to assess for the client's understanding, and also getting the information I need. I mean, even a question as simple as who's in your family, that could be a complicated question. There's lots of people in my family, and now I'm having to recall everyone, and where should I start? If I say, do you have any children? Well, that's a much easier question to answer, right? And then again, it's what we're doing as advocates to enhance our clients' capacity. If I'm asking these big, broad questions that are going to force my client to recall a lot of information and they can't do it, then maybe I'm saying, well, she doesn't understand what I'm saying, right? Like she can't answer this question, but really it's because I'm asking an inappropriate question. And if I can narrow my question down to something that's going to require a brief response, then I'm going to think differently about what she's able to understand and how we're going to be able to interact in this legal case. And then I'm going to repeat often, right? I'm going to summarize after each issue what the subject is. And sometimes you do have to hear it over and over again. And especially if it's a concept that the client's unfamiliar with, which is a lot of times with, legal issues. So I'm going to tell them multiple times what guardianship means, or I'm going to tell them multiple times what a breach of lease means, or what does the definition of disability for Social Security benefits mean? Because that's unfamiliar, and you have to hear things over and over again for that kind of concept to stick. And then I'm gonna check periodically for accuracy, right? I'm gonna make sure that they understood what the legal issue is or what options I gave them, or they made a choice and I advised them, look, the consequence of that choice is this, and they say, okay. Well, I'm going to come back around and I'm going to make sure that I'm going to bring up that again and say, so do you really understand that this is what this means? And again, that's good practice for all clients, but I'm going to do it more times with my older adults. And then the last thing about client interviews, as attorneys, we have a very focused mind and trying to figure out what's relevant, what's not, and trying to get that information. And so in the same kind of breath of slowing down, open-ended questions, is that you want clients to be able to kind of tell their story and say whatever they want to say about that legal issue, because sometimes you don't know what's relevant and not relevant until you walk out the door or you get more information. So just be hesitant to try to interrupt them or try to redirect them, and kind of just let them in that first meeting lay the lay of the land and let them give all the information. Maybe they want to talk about their neighbor for 50% of the time, and you're like, gosh, that neighbor is not important. What we're talking about is what you have done or what the landlord's, talking about your unit. But maybe it does matter. Maybe, what the neighbor does matter, because now it looks like there's discrimination or there's something else. So open-ended questions, don't cross-examine them, don't rapid fire question them, allow them to tell them, your story while trying to get those facts for your particular case. Okay, and again, working with older adults, I'm sure that we do this, but it's always just important to kind of remember to verbally empathize with our clients. It doesn't take a lot of time to do, and sometimes it can make a huge difference. And so a lot of these legal issues are very, very important to our clients. They're very serious, you know, just kind of reflecting for a moment that sounds really difficult. And I'm so sorry that you're going through this. And you know what? You and me, we're going to solve this together, right? That took 10 seconds. It's genuine. I know I feel this. I just don't always say it. You know, as an attorney, sometimes you're just kind of moving through A through B through C, and you forget to kind of just slow down and remember that your client is a human going through a very personal issue, and don't forget to kind of to verbally express that. You know, the client will feel more understood. They might feel more engaged. And we know that, you know, it increases client satisfaction if they feel connected to their attorney. So, you know, as you're leaving your client, when you had that in-person meeting, you're going to make sure that you leave your card or your contact information. When I worked at Legal Aid, they had a lot of great brochures. I would probably bring a few brochures to leave for them that would discuss the legal issue or maybe other things that I think are going to come up. Maybe additional community resources, upcoming events that they might want to attend. And then depending on how much information I knew beforehand, I might type something up that I knew we were going to discuss. I knew when our next appointment was, and I might have that available, or I'm writing. I mean, I will occasionally handwrite notes and say, next meeting, the 5th at 2 o'clock. And then I'm going to find these documents, and then I'm just going to put them, or call sister, call mom, and I'm going to leave them something in writing with kind of the next meeting, the to-do list, what their homework is, so that they just have that to kind of reflect on after I've walked out the door.
And that's a great segue. Thank you, Caitlin, to communicating in writing. So this is a great chart I found just talking about the differences between the things that stay that decline with age when someone is reading, and things that stay the same. Vision can be poorer, and in that we may compensate with bigger fonts and other strategies, which I'll discuss in a moment. Older readers tend to process information more slowly. It's hard to multitask, and that's why, again, we talk about issues one at a time. It's really just hard to hold several balls in the air and be thinking about several issues. It's harder to focus in the wake of distractions. I may ask the client if we can turn the television off if they're reviewing a document. And it is more difficult for them to be flexible. At the same time, there are some parts of reading that don't change. And then there's also some, I think, advantages to being an older adult in the world, of course, having more wisdom, really relying on rules versus just assessing so many different choices and kind of experiencing that paralysis that some younger generations feel. And being able to recognize pictures and processing language stays the same. So when I first started, I was writing letters the way that I always would, Times New Roman, size 12, but I now use a bigger font. I think glossy paper is a no-no. Using a more matte paper helps vision. You also want, especially if you have a multi-page letter, to make sure that the format is the same on every page. I think a lot of us will have a cover sheet with our organization's logo and then maybe different documents after, and that just makes it more difficult to understand. So just having that same layout. Lists are often very helpful. Things like tables are not so helpful with just so much information going on at the same time. Repetition, as Caitlin alluded to earlier, just making sure that you are frequently referring to the information. It's okay. I think in law school, we're often taught to be succinct and to get to the point. And while it is important at the very top to maybe address the point, it is okay to explain it several times in different ways, especially if it's a legal term of art. You may not even need to use that term of art at all. That may increase confusion. Instructions are helpful. And then also just don't send people on wild goose chases for various parts of information. If you refer to an agency on page 1 and then only list the agency's number on page 3, you're going to force someone on page 1 to flip to that and they might not be able to find it. So if you were mentioning something with the phone number or the name of an agency, just list it there. It's okay if you go on to the second page. It's more important that the person just understands and can have that information handy. As Caitlin talked about, we often want to follow up our verbal communication with a written document. A lot of my older adults just like to have files. I will give them a special folder with my organization's logo on it where they can just keep everything. And you want to say when and where you met, the issue and the facts, what I presented to you, this menu of choices, what you chose, and I may indicate if I advised against that choice, but it's important, and then how we're going to proceed together. So just as an example, we just listed the guideposts that we had in the previous slide. We met on this date at this time in this location. This is why you contacted our office, because your landlord sent you a breach of lease notice. This is what we talked about, the facts of the case. And you acknowledge that the landlord is correct that you smoke in your house against the lease rules. I advised you of your options. We could contact the landlord and try to mediate. So where you could stay in your apartment, we could go to court, or we could negotiate more time and move out. You told me you would like to move and you would like me to negotiate with more time. I said I would do this while you looked for alternative housing. So that gives them a to-do. And your follow-up, I agreed to call you after I spoke to the landlord. And then again, noting if you disagreed with the legal avenue the client has chosen. That's important for documentation purposes and potential grievance issues down the line. Documents to prepare. Again, we talked about written to-do lists, arrangements for the next meeting. Sometimes I'll be on the phone with the client and ensure they're writing it down on their calendar, but you might also want to follow up with a letter. And then my clients often like to have their the copies of the signed documents. We want to have it in our legal server, whatever document management system we have, but it's nice to bring those or photocopy it and mail it to the client later. I often will pre-stamp and pre-fill the envelope just so it's as easy as possible for them to get something to me.
Okay, so the last form of communication that we're going to talk about is via the phone or kind of virtual video calls. I know I've been doing a lot of Zoom calls with my clients, so it feels very timely. If you can do a Zoom call or some type of virtual call, that's going to be more beneficial than a phone call. The comprehension is going to be lower over the phone. There's a lot of obvious reasons why a video call would be more beneficial, right? You get to assess nonverbal communication. I think I was just telling a colleague the other day that I was speaking to a client on a Zoom call, and I always ask everybody to leave the room so that I'm alone with my client. And my client was almost nonverbal. And I'm speaking to her and she just keeps looking up and she's just not paying attention. And so it was obvious that somebody was still in the room. So I said, hi, is there somebody still in the room? Because she's clearly looking at someone. And they said, oh, I'm so sorry. I thought you wanted me to stay in the room. And then the social worker stepped out. I would never have gotten that same clue if we were, over the phone and we were able to communicate, in the video about things that she needed. And again, just the same benefits of going to a client's home or being in person. We get to see, what their house looks like, how they look, what they're wearing, how they look, which is all going to be beneficial. You may need a third party to set up the call. I'm sure a lot of advocates have gotten very creative over the last, few years when we've been trying to keep our older adults safe. I often have to think creatively to get to my clients. The clients that live in the community alone often don't have access to the internet or a phone or a tablet that would have Zoom. But there are other people that come into that home that might. So you want to kind of think creatively in that way. Is there a family member that you can coordinate to set up a call when they come and visit? Is there a caretaker? Sometimes in senior citizen buildings, there is a business office, and occasionally they'll let me, if I bother them enough, they'll let me jump on a Zoom call or help me organize a Zoom call. So you kind of have to think about all the different people that do interact with your client to be able to get that done. Another example is clients that go to adult daycare. I've been able to call the adult daycare and say, she's coming in on Tuesday. Can I just, call FaceTime, Zoom, and they've been able to arrange that. You also kind of want to be prepared to have multiple different platforms. I think I have used everything, the Google Duo, the Zoom, the FaceTime, the WhatsApp, whatever the person has, I'm willing to do it. I do a lot of FaceTime on my cell phone because that's a lot easier than setting up Zoom calls. So, just continuing to try to be creative to find solutions to put eyes on our clients if we can't get to see them in person. So if you do have to speak with them over the phone because you don't have that option to see them in person, you just want to speak clearly, again, not yelling, because then that, one, distorts your speech, but two, makes it seem like you're upset with them. You do kind of want to assess more frequently because you're not able to see their facial expressions about if they're confused about something or if they completely understand what you've said. You want to be patient, kind of give more signals that you're moving on to the next conversation or topic. Don't interrupt. Make sure that you give them opportunity to ask questions. And then even probably more so than all the other meetings, maybe follow up with something in writing to remind them of the discussion that you had, who you were, to kind of get that information to stick. So that is the end of the best practices. So we just threw in a few hypos and a few questions just kind of for fun to see if the information that we conveyed stuck. So I will let Andrea go through those.
Great. So we just have 3 questions. We're going to pretend that we are speaking with an older adult client for the first time on the phone, and we're just going to game through what we're going to do next based on what we learned today. So we have 83-year-old Mrs. E. She contacts our office because she just received a letter from her landlord accusing her of breaching her lease and seeking to terminate the lease. Mrs. E has lived in her apartment for 12 years and she's never had a problem with the landlord before, but her 19-year-old granddaughter recently came to live with her. She mentions that the landlord has complained about parties and noise, but she's reluctant to get into the facts during the first conversation on the phone. The granddaughter is not on the lease, only the grandmother is, Mrs. E. When you talk on the phone, she asks you to repeat yourself several times. Mrs. E doesn't have a car and has difficulty leaving the apartment. So our first question is, when we're going to the first client interview, how should we proceed? How should we interview her? Should we ask her to turn up her hearing aids and call her back at a mutually convenient time, maybe in the morning? Should we say, can your granddaughter set up a Zoom call on her smartphone if she has one? Or should we travel to Mrs. E's house for a face-to-face visit if your organization allows it? Does anyone want to put in the chat what they would do? Okay, give it one more minute. So you're probably all thinking, C, yes, thank you. Thank you, Victoria. If possible, it's great to be able to assess her living conditions, accommodate her. It seems like maybe some problems with hearing and issues with transportation. B would maybe work, but again, because there seems to be some sort of conflict between the granddaughter and the grandmother, we want to make sure that the granddaughter is not involved in that first conversation. So Zoom might not be the best unless we could ensure privacy. A face-to-face conversation in the home may be the best if you're able to do it with masks. Okay, so we decide to go, choose your own adventure, to Mrs. E's apartment. Her granddaughter lets you in, and then she just sits down in the living room where Mrs. E is waiting. How should you proceed? I see that I'm a little frozen. So A is, well, the legal issue involves them together. The granddaughter may be partying, so let's just talk to them together. B, ask the granddaughter if she wouldn't mind stepping into another room or leaving the house for a walk so you can talk to her grandmother alone. Or C, hand the granddaughter a third-party authorization form and have her sign it and then just proceed normally. What would you do?
I guess we should say, what would you do first?
What would you do first? Thank you. Ding, ding, ding. Another right answer from Victoria. Do you want, Caitlin, do you want to talk about why it's B?
Yeah, I think there's obviously a conflict here. The granddaughter sounds like the reason for the breach of lease. And so best practice is always going to be to talk to the grandmother first. She's our client. And then after that, if she wants her granddaughter to, join the conversation, that maybe we can do that. And at that point, maybe we have her sign a third-party authorization. But first, we're going to have to talk to our client first, alone.
Great. I apologize. On our very last slide, it looks like it's the slideshow's not cooperating. But for our last question, so we speak with her for an hour. You notice that she's having difficulty remembering the possible options to the matter. And you're going through all of the things that we talked about. You're trying to repeat, you're summarizing, you're doing one topic at a time, but it's just really overwhelming. And she is having a difficult time restating those to you. How should you follow up? A, schedule another meeting to discuss the issue again, send a letter summarizing your discussion, review existing supports to determine ability to enhance capacity, determine any factors that may be impeding her decision-making abilities, or all of the above. And thank you, Victoria, for identifying that we should perform all of these tasks, schedule another meeting, send a letter, but there may be other things in the community, agencies that we could involve in this case to enhance her capacity. Do you have anything to elaborate on this, Caitlin?
No, I think that's it. We're going to ask if you guys have any questions. I did just throw in the link, the Nickler kind of practical guide. This is not the ABA guide that we're talking about, but it references it often. The ABA guide you have to pay for, right, Andrea?
Yeah.
Yeah, you'd have to purchase that. But if you do go down to the bottom, it does have the capacity worksheet for lawyers that maybe you want to print out and just kind of familiarize yourself with. Otherwise, that is the end of our presentation. If anybody has any questions, feel free to drop them in the chat, or you can always email or contact us at MVLS.
And I just want to mention, Victoria had a great point, that you could also let the client know that she can call to ask questions. I think that's important as well. I always try to be available because sometimes people say, yes, I understand. And then half an hour later, 2 days later, they have another question. So just being available that way is important. Thanks, team. Great. All right, so thanks so much. We have a short survey at the end of this, if you wouldn't mind filling out. We can also follow up with the recording if anyone would want it, or anyone in their office wants to view it and didn't get a chance to attend. Thank you so much, Caitlin, for all your expertise and helping me present today. Have a great day, everyone.
Thank you.